Good evening, ladies and gentlemen. You're welcome to one more in our series of webinars for our construction clients. If you have not been able to join us hitherto, our objective in these seminars, in these webinars, I should say, is to assist our clients in the construction project, not by way of giving a law lecture, but to bring together some experiences that we have in order to assist our clients in delivering their projects. The object of this evening's webinar is how to avoid the risks inherent in the procurement of construction contracts. By way of introduction, if you've not been to any of our prior webinars, my name is Samuel Okoronkwo. I started my professional career as a quantity surveyor, became a project manager, and somehow finished up finding myself at the bar, where I do, amongst other things, a substantial amount of construction contract law. So as a barrister, what I tend to do is assist my clients with drafting contracts that achieve their objectives, advising them on how to manage out disputes in contracts and how to resolve disputes in construction contracts. That may well be by way of adjudication, arbitration, or indeed litigation in the courts where alternative dispute resolution has not worked well. Okay, so trying to get into the meat of what we're supposed to be talking about this evening, before I address the issue of ambiguity, which I say is the primary cause of most construction contract disputes, I think it is proper to draw attention to the necessity to actually make an intelligent choice of the form of contract that you're going to use for your projects. Now, you may well be the employer, the architect, maybe a QS, or indeed a contractor. More often than not, you have to advise on the appropriate form of contract for the project in hand. I need not tell you that if you choose to select a JCT minor works contract for a civil engineering project, that you're having trouble stored up for you. Therefore, to that extent, try and be able to understand the projects that you're looking to deliver, then select an appropriate form of contract to match it. And once you have done that, one of the key things that you need to look out for is what I simply call ambiguity. Now, you have to be clear in what the objects of the contract is. If you can eliminate ambiguity at source, you will eliminate a substantial amount of disputes that you encounter in the construction arena. Now, solving a construction dispute through adjudication, arbitration, or litigation is an expensive exercise. That is what I do day in, day out, and I know that to be a fact. And if you have had the misfortune of encountering a construction dispute, you will well agree with me. If you have not been touched upon, if you have not encountered a dispute in construction, I highly recommend that you try and avoid it if you can. Now, because it's far more cost effective to avoid it rather than try to become embroiled in one and then attempting to solve it. So in this webinar, we'll be looking at 4 key areas of risk. Number 1 is your contract objectives. And the second one is your contractual obligations. So with respect to the first one, how do you ensure that the contract objectives are fulfilled? Every contract has its own objectives. What are they, and how do you ensure that they are fulfilled? Clearly, if you are a member of the project team, you have contractual obligations that you have to perform in that contract. How do you identify the difference between your contractual obligations and the contract objectives? And indeed, not just the difference, but how do you make it marry one another, ensuring that your contract obligations are focused on delivering the contract objectives. We'll touch upon variations and how to manage variations during the life cycle of the project, and then quickly touch upon managing program overruns, and that is to say, time management during the course of the project. Okay. First and foremost, how to ensure that the contract objectives are fulfilled. For a start, in every construction project that you are taking part in, there are written objectives of the contract and there are unwritten objectives of the contract. Now, every project that you are going to undertake will have three cardinal elements. The first one invariably will be the budget. In other words, what's the contract sum? How much is it going to cost to do? And if you're the employer, you know what the contract sum is, and you probably have a little bit of, if you like, a contingency allowance, giving you a little bit of flexibility for what figure you would actually final account at. And that is the budget. That is one cardinal element. The next one is the timescale. When is it going to start? When is it going to finish? And the third one is to what quality standards that it is going to be built to. Now, one needs to identify at the outset what your contract objective is. So I'll give you an example. If looking at some of the pictures there, if you're doing a retail project, and retailers, of course, are driven to the seasons of, say, Christmas or Easter. If you're doing a retail project that has to be completed and you're in the ember months, you will find that your client is more likely, or the employer is more likely, to tolerate a little bit of a budget increase, provided you deliver on time for them to catch the Christmas trade. Or alternatively, if there were items of quality that didn't quite match expectation, but nevertheless, you've met that timescale. And in fact, whilst I'm on that subject, an example comes to mind, which is worthy of sharing. I was being briefed by a project manager who had received notice from the employer of a professional negligence claim. The basis of the employer's professional negligence claim was that the project manager had allegedly determined the construction contract. Following the determination, the main contractor had then brought proceedings against the employer for unlawful determination of contract. So take two quick steps backwards. The contract was with respect to a school, which residential accommodation hostel for students. The contract provided for the contract to be completed in sufficient time for the students who were coming in, both national students and international students, to take up their accommodation sometime around about September. Now, the contractor came to the conclusion that the architect was not delivering construction working drawings in time, and therefore he was busy recording the delays. And as far as he was concerned, there was no way that he was going to complete in sufficient time for the students to take up their places. Now, the unspecified, the unwritten lead element in that contract was time, completing time for students to take their accommodation. As the contractor proceeded in what he considered to be at the rate at which he can build, the project manager took umbrage because he wasn't moving as fast as he thought he should be moving, proceeded, issued notices under a contract, and determined the contract. The contractor then turned around, and then, of course, because when the contract is determined, really, it is the employer that he has to follow. So he brought proceedings against the employer. Employer then took legal advice. The employer's solicitors advised the employer that, having examined the contractor's claim, they were more likely to agree that the project manager had determined the contract wrongfully, and as such, it was necessary to serve a notice on the project manager that there be a professional negligence claim against the practice. And of course, the practice then approached me, will you please, Samuel, defend us against this professional negligence claim? Having studied the documents, I felt that it probably was a lot less challenging to defend the contractor's claim against the employer rather than to defend the claim that was going to come against what was then my proposed client. So I suggested that to the project manager. Why don't you go back to your client, the employer, try and agree a truce and say, let me, the project manager, take control of defending against the contractor, because of course, if we were successful in that, the claim against you wouldn't come through. But of course, if we did fail, then the chances of the professional negligence claim was higher. My project manager client departed, went and had sessions with his client, and as it turned out, they agreed that should be the case, and therefore one was then briefed on having to defend against the contractor's claim for wrongful determination. Suffice it to say that we were successful in defeating that claim, and having defeated that claim, we therefore saved the project manager from a professional negligence claim, which would have had severe impact. Now, that is a classic case where there was an unwritten contract objective: time at all costs, get us time, even if you don't quite meet the budget, deliver it on time, because we have students who are coming to take occupation. There's no way that the school term wouldn't start, but you have to deliver on time. Now, that was an unwritten objective. That was not, to my mind, on reflection, recognized at the earliest possible opportunity and communicated effectively down the line and persistently. So that takes me down to contract correspondence. I said that once you have identified the written and unwritten objective of your project, capture it in correspondence, communicate it, not just at the outset, but repeatedly and consistently, so that all stakeholders will get a buy-in. They will all recognize that, come what may, delivering this project on time was primary and everything else was secondary. Again, I see definitions where one looks at papers and you say that the project is to be built to the highest quality standards. What does that actually mean? Not much, to my mind, because every single project ought to have clear-cut specifications identifying exactly that which is to be delivered. Now, if you say build this to the highest quality standard, it doesn't mean anything. It's ambiguous. It causes difficulty because it may well then become subjective rather than objective. So it is imperative at every opportunity to identify what are your contract objectives and then be able to share that and ensure that you're screaming it from the rooftop so that everyone buys into it. So the next point that we touch upon is how to identify the difference between the contract objectives of the type of example that I've just given and what is your individual contractual obligation. Now, it isn't just a case of identifying what that difference is. You ought also to be able to then relate your obligation to the objective. So the first question here to ask is, what part does everyone play? If you're a member of the design team, the project team, the construction team, as we all know, it's a team effort. No one person goes and starts a project and delivers it by themselves. It's just like playing football. So who is doing what? Now, your contract will obviously be clear. The architect, you're in charge of the design and the information flow, which the architects in the house should be aware of, because if you're responsible for the design, you're also responsible for the information flow and the coordination. And in this case, a couple of examples come to mind. So I was part once of a substantial shopping center construction project where the intensity of the program required a substantial amount of in situ concrete work in terms of the frame, the floors, to proceed at a rapid pace. Now, it transpired in that case that the M&E drawings, including the air conditioning drawings, were running later. They were coming behind the architectural design as well as the structural design. What then, of course, happened in that case was that the structure was being raised at a significant rate, only to find that when the M&E drawings came, it identified a substantial amount of services traversing both vertical and horizontally through walls and through floors, where the holes were not cast in. And as any of you that have been involved in reinforced concrete construction will know, if you have to get AC ducts through a vertical floor where it doesn't exist, you just have to cut the hole. And if you're going to cut that hole through a reinforced concrete slab, you cannot but diamond drill them. Now, if you're diamond drilling, what happens? The diamond drill itself requires a substantial amount of water going with the diamond drill because it's red hot. So what you then find in such a situation is that whilst you're diamond cutting literally hundreds of holes through already cast concrete structures, in essence, very few other trades can come behind. You all of a sudden have held up everything that is supposed to be coming behind. So you are not just dealing with the cost of a substantial amount of diamond drilling post casting the floors, casting the structure, I should say. You're also dealing with a substantial amount of water because the dry lining that is supposed to come behind it can't. Because you bring the dry lining in, of course, you're then requiring a substantial amount of skips to take away materials that have just come to site and been ruined and removed. So what do you have there? Is a consequence, I say, a product of silo thinking. So I'm the architect, I'm designing the information. I'm the M&E contractor, I'm just putting in the, if you like, M&E carcassing and then to come with second fix afterwards. Who is actually coordinating all of that? That coordination is ever so essential. You can't allow silo thinking. If you're the project manager, if indeed there is a project manager, and absent a project manager, unfortunately, it lands on the lap of the architect. You have a job of work to bring the professionals together, bring in the principal contractor, bring in the specialist trade contractors to think together. Look at the construction program that has been put out. Interrogate it, test it for its efficacy. Does it work? Does it work practically? Has the program been tested? Is anyone testing it? Now, another example that hits me in the course of trying to bring this point home is, if you like, a substantial residential project where marbles have been specified, some marbles coming from Italy. Now, look at the supply chain, look at the delivery period, and then look at the program time that's been allocated for it. Do you have sufficient time to procure and to get delivery and then to fit? And another example, a different project, but the same issues, where it included a rather luxury swimming pool, where at the time of nearly completing the tiling of the swimming pool, the spouse of the employer takes a look and says, no, I dislike these tiles. Now, what has to happen? The contractors have to stop work. They have to remove tiles that they've already installed. And when, of course, they presented samples and the lady of the house chose what tiles she required, the tiles had to come from Spain, and they were on a 16-week turnaround. Now, that's a potential 16 weeks delay on the project. How has this been articulated, integrated? Is it understood what the consequences will be? Has it been mutually acknowledged and therefore accepted that the project can be delayed for 16 weeks? And what will be the consequences for the contractor for the operatives that are now lined up, finding that they can move to the next stage of the works. And of course, when they say 16 weeks, in fact, allow for 20, because 16 will be for the factory to take the order, manufacture, and then start delivering to you. So identify what the contract objectives are, understand what your contractual obligations are, and try to see the point of intersection of the two. But more to the point, identify where they are divergent, because where they are divergent is where the difficulty arises. You want to bring them together, ensuring that what is being articulated in the construction program is practical and deliverable, identifying that the specifications that have been put forward are obtainable and within the program, and that the materials that are specified can, of course, be acquired during the time and be able to be installed. So, of course, the examples that I give highlight variations. So how do you manage variations during the life cycle of the project? Now, for a start, the variation is the bane of, if you like, bane of every construction project. However much you try to avoid it, it will happen. The examples that I've given you already identify where variations are inherent and where they've been enforced upon you. Now, but what you must do with variations is recognize that dealing with them has to be contemporaneous. So issues arise on a project, and when they do arise, you have to rise to them at the same time. The biggest difficulty that one experiences is when a variation arises, and in the stampede to try and complete the project, both the employer, the architect, project manager, and the contractor, the objective is get it done first and we worry about it later. The concept of get it done first and worry about it later is tantamount to a dispute, because when the variation has arisen, you need to record it contemporaneously, acknowledge it contemporaneously, and try and quantify it contemporaneously. By that, I mean at the relevant time that it is happening. So if you have identified a variation, publicize it. Now, if you're the one going to execute the variation, mainly a lot of contractors fail to pick up their variations until they get to final accounting. That is the worst possible time, because if you leave it to final accounting, you're most unlikely to recover. Now, once it is happening, that is the time that you draw the project manager's attention to it, the architect's attention to it, and the employer's attention to it. And when you draw their attention to it, you want them to acknowledge it, recognize it. It's then incumbent upon you to try and quantify not just the cost implications, but also the time implications. And once you've quantified it, even if it were approximately, communicate it. And to contractors, I advise strongly, once you've communicated it, just ensure by your next interim valuation that you try and include it. Because once you try to include it, you then are drawing the attention of the decision makers to either agree or disagree. And if they disagree, to what extent? And that is where you begin to see the divergence between the two parties. Those are the key concepts of ensuring that you're managing your projects safely and professionally, capturing your variations when they happen, because they're bound to happen, but also appreciating that there is a knock-on effect of every piece of variation. Now, delays and changes at one stage will always affect the next stage. That effect on the next stage does not always mean an extension, because you can, of course, if you just sort of take two quick steps backwards into your programming, every construction activity has a start, the earliest start date and the latest start date and the duration. And therefore, you can calculate what float, if any, float the spare time that exists within the delivery of that work element, of that activity. Now, although it may be impacted by a delay, there may be a float already inbuilt in the activity that would enable you to absorb that, if you like, impact without it affecting the critical part of your program, or it may not. As the case may be, if you recognize that it impacts your critical path, then you must immediately screen and draw it to everyone's attention, because unless you do, unfortunately, you will be the one alone bearing the consequences of it. Now, the other thing to recognize in circumstances we find ourselves in is inflation. Now, we are now back in the situation where the cost of everything is rising, and there is a substantial construction cost inflation that is presently prevalent across the board. Does your contract cover price inflation? Do you have fluctuation clauses? You have to be careful with contracts that do not cover this, and you have to make the provisions for it just to ensure that you're not overly exposed. Now, I referred to an example of contract abandonment. Now, is a pragmatic approach to difficulty that some people may take. Now, an example readily comes to mind on this. Now, this example goes like this. I received a brief in Chambers, and although that brief was primarily about a different aspect of the law, what transpires, and this actually is with respect to a project at St. Pancras in London. What happened there, it's, of course, St. Pancras is now a major international train station. Now, a client, a high-profile client, had taken some retail space where they were going to fit out and sell some high-end products and services. Now, in the course of that, they were required to retain contractors that were in the approved list to work at St. Pancras. As part and parcel of retaining the contractors, to my surprise, they were required by the contractor to pay a substantial amount of deposit. And I think that the deposit was something of the order of £200,000. So having taken £200,000 to begin what was described as pre-construction, elements of design, early procurement of certain components, the contractors unsurprisingly ran into financial difficulties. And when they ran into financial difficulties, the directors of the company decided that the best thing that they were going to do was to abandon the project, to liquidate their company. They proceeded to do that. Now, originally, soon after liquidating the company, my client, as it turned out in that case, received a letter, an initial letter from the liquidators to say, we recognize that one of your projects were one of the live projects that the liquidated company was dealing with. We know that you paid a deposit, some components appear to have been acquired, and you may well be able to access this, but regrettably the company can't proceed anymore. Now, a couple of weeks later, they received another letter saying, notwithstanding what we told you before, we find that the components being acquired on your behalf are actually part and parcel of the company's assets, and therefore you're no longer entitled to them. And therefore you're not getting them. So clients were there, the deposit they paid had disappeared, the components that they felt that they were going to be able to get were no longer available. Now, almost 2 weeks after receiving that letter, then they received a letter from a different construction company. Now, being the new company formed by the directors of the old company that had abandoned the project, and they were telling the client, he said, we note that in company X, we were unable to proceed with your project, and therefore you lost everything. But if you care to return to us to use our new code for your project, we have the benefit of your designs that were already done, and you may not have to pay for those again. We'll give you some credit, i.e. if you came back to us. Now, the example that I'm trying to bring out in that case is that the directors there felt that it was the only thing they could do was to abandon ship, abandon that contract, and in fact liquidate their company. Notwithstanding as stupid as it transpired for them, was that Phoenix is of course prohibited in law. They couldn't do what they were doing, and indeed the proceedings that followed subsequently was to pursue them down that line. But then again, if you are the employer, check the situation of your contractor. Are they potentially in a difficulty that they are likely to take the pragmatic approach that is too difficult for them to continue and to abandon the contract and therefore leave you with a substantial headache? And therefore, what is the pragmatic step for you to take in order to either assist them or to protect yourself, or at least to ensure that all, might I say, assets that are acquired in the name of your project are indeed yours and not part of the insolvency estate, as the case was in that case. So that is how to look at the issues that arise in the life cycle of the project that you're dealing with or the contract that you're dealing with, in terms of variation and how that can actually, as it were, get out of hand if it's not well controlled. So how do you manage program overruns? What are the things for you to look at? Not to forget that I say always, every project have issues with respect to the time, program, the cost, the budget, and of course, the quality. Now, I say that the beginning of managing time on any project is the construction program. Now, the construction program has to be robust. To my mind, it's not a static document. It's a living, dynamic document. Does it actually make sense? Many construction programs don't, because not a lot of contractors spend the time that is necessary to think through, because I see a construction program, to my mind, as the super highway that delivers the project from start to finish. Now, in the course of looking at that program, has it been tested by all the stakeholders? What is involved? How is it likely to work? I can't overstress that. Now, in your programming, I've touched upon already, trying to identify the critical path, through which activities are there during the course of the project where you cannot afford to lose any time. Identify those and protect them. Now, more often than not, if you're building through the winter months, inclement weather is a significant excuse, as I see it, for program overruns. But then if you're going to be building through the winter months, have you made an appropriate allowance? Have you designed your structure such that you can achieve the earliest possible watertight date? In other words, by what date is the roof supposed to be on? Because let's face it, once you can get the envelope of your construction project on, then a lot of activities can happen internally. You may well have to get artificial lighting, but at least you don't have rain, you don't have driving rain, you don't have snow, you don't have excessive wind coming in on the inside. So if you have your project construction program adequately done, and if you're the contractor, give it to the employer, give it to the architect, give it to your trade contractors, ask for comment on it, invite people to look at it and confirm that what you're allocating for them to do, that they can do within that period of time. And for architects particularly, when you look at a contractor's construction program, think that the program is aimed at you because you are required to provide the working drawings in sufficient time for the various activities to be procured and therefore be able to be delivered on site. So if you look at a program, ask yourself, in fact, most very well-versed architects will turn around. Once you pick up the construction program, invite the contractor to give you an information release schedule, because they should be able to deduce from the program that they've done, we're required information for this on this day, on that date, on that date. Now, some contractors will turn around and tell you we require all the information on day one. Of course, they can't have all the information on day one. You will engage them and say, look, I have to direct my resources to suit. And when you receive the information, so give me a schedule. Although you request that schedule, try and prepare your own schedule as to when you'll be releasing the information. Then, of course, you can compare it and see whether it works. And if it doesn't work, get it changed at the outset, because it's easier at the outset to agree adjustments to program than it is for you to start trying to change them post the event, because then, of course, that's when the difficulties arise. And then look at your watertight date. Try to exclude inclement weather if you can, mainly from the employer's perspective. The employer will be asking that. How are we sure that as we go through the winter months, we can't find our site lying idle without any work being done there? Okay, so I tend to say, bringing all of this together, that a stitch in time always saves 9. It's better and cheaper to prevent disputes than to become embroiled in them. Now, the cost of one dispute, I say, in the cartoon character, that but what actually happens that once it begins is a tug of war, and both of you are pulling at destruction. With variations, you're always unlikely to get the results you expect. So if your variations have arisen now, and you have not announced them now, you have not quantified them now, you've decided to leave them to the end of the project, you can be as certain as you will be that you won't get what you're entitled to in that regard. Now, your program delays, you will also find that you probably would have incurred additional increased cost of labor without recovery. And in fact, it isn't all increased cost of labor that you'll be entitled to recover. Now, in dispute resolution, the time taken and the costs incurred in resolving a dispute through a formal channel can, in most cases, outweigh the benefit of the resolution itself. So ask yourself, should you be trying to manage that? Should you be trying to avoid that than letting that happen? And when it happens, in the examples that I've given you, it doesn't just impact the employer and the contractor. The professional consultants in the middle get to bear the burden as well, because the way most standard forms of contracts are written, the employer is silent. All of the employer's work is done for the employer by the professional consultants. And in the case of the project manager that I've given you, you will find that if you're the professional consultant, you invariably are in the firing line once the hostilities begin. So better to, as the case may be, get it right first time. So in trying to look at the projects you have, they're worthy of a review, if not by an external expert, by yourself in the first instance. We have internally produced for our clients a 12-point checklist that runs through what you should be mindful of from the commencement of your letter of intent, or indeed a formal contract, if you actually signed one, going through to your final account. Now, if you want to avoid preventable disputes arising in your projects, you can review them yourself, and if you believe that you require assistance, and by all means have no hesitation in asking us, and we will be happy to assist you in that case. Now, that is a summary of what I intend to tell you in the first instance. The nature of these webinars is that I get to speak for the first half of it, sharing my thoughts and experience with you. And the second half of it, of course, will be a Q&A that is open to you, because whilst I'll give you one or two examples, I will generalize, if you like, the matters that I address. There are specifics. There are other webinars where I go into greater detail in specific aspects, but on matters such as the type that we're dealing with this evening, I take a general view, it's a whistle-stop tour, that I give you my thoughts and share the experiences, and by all means, fire off your questions as you may have them. And that is my webinar to you, as it were. And the next will be your questions to me. So I look forward to hearing if you have any. Thank you very much.
Hi, Samuel. Are you able to hear me?
I think I'm able to hear you. Is that Anthony?
Yes, it is.
Hello.
I have a question in regards to project scheduling. Now, we mentioned the importance of assessing both the objectives and the obligations in regards to the contract. But when creating and communicating schedules to the various stakeholders, to what extent should we be providing them the tolerances for durations, specifically in the case of something like limited material availability? So if it were to be executed prior to a time frame, it wouldn't be an issue, but should it be done afterwards, then there's more of an issue. How do we balance that?
Anthony, tell me, which side of this are you looking at? Are you looking at it from the employer's side or from the contractor's side?
From the contractor side. In my personal situation, I'd be expected to provide material to the general contractor in time. While I'm able to do that, I have to also consider the timeframes, and if it gets held up within their court, then I'm expected to accommodate for those changes.
Are you an architect?
I myself work for a specialty glazing subcontractor.
Sorry, say that again.
A subcontractor.
Oh, you're subcontractor. Okay. Now, look, the point is in trying to meet the contract program, I take it that by the time the principal contractor comes to you, they're going to give you a window within which they want you to deliver, correct?
Yes.
Right. Now, for you, for specialist trade contractors, my experience is that more often than not, when the principal contractor is bringing you on site, you may well find that the site is not ready to receive your components.
Absolutely.
Exactly. Now, if the site is not due to receive your components and they're trying to force you in, you want to, if I were in your shoes, 2 weeks before I'm due to start, I want to pay a visit to site. And you need photographic evidence with your mobile phone and saying, look, if here is the structure, if this is the opening in which I'm supposed to fit my components, they're not ready, or the tolerances are not there. Now, what are you, principal contractor, going to do to ensure that this happens? And that is the time that you serve the notice whether or not you are able to come and fit. And more often than not, you will find that the principal contractor say, look, we hope it will be ready, deliver the components, and then you can fit afterwards. The reasoning for inviting you to deliver those components is that they can be included in the materials on site valuation by the QS when he does his interim valuation. Good as that might be for cash flow for the principal contractor, ask yourself, how are my components going to be protected if they're on site and they are not being fitted? Because what happens then is that the contractor will step back from accepting and acknowledging liability if another trade contractor who is rushing to finish damages it. So for you, I would check and ensure that the opening is actually there and ready. If it is there and ready, if you like 30% of it is there and ready, I'll come to site, I'll fit that 30%, but then you need to notify the contractor. This is now a 2 or 3 visits or 4 visits job rather than the 1 visit that we quoted for. Now, it doesn't mean that you're asking for extra money. You are stating the obvious, stating the facts, such that it is taken in case, and it's often the case, that subsequently when the principal contractor is blamed for not finishing in time, that he turns around and blames you for not finishing in time. But what he doesn't recognize is that the trade that was going ahead of you had not got it ready for you in time. Now, I tend to call it is work package breakdown, where the principal contractor is getting a lot of trade contractors to fit together to finish the project. So you have the interfaces between the packages. It is managing it. So unfortunately, because you're further down the food chain, the responsibility often is devolved down to you to come up and warn the principal contractor, this is not ready. And retain a photographic evidence, you'd be surprised how much photos taken on mobile phones and even sometimes videos taken on mobile phones play a great deal of, play substantially in resolving disputes these days. Because you can say, we have agreed this time slot. I have visited site on this date. It is ready or it isn't ready. And if it is ready yourself, crack on with it and then get on. I recently dealt with a case where, interestingly, the specialist trade contractor in your position was requiring, and indeed did receive payment in advance of the date given for him to come and fit. And that is notwithstanding that he hadn't actually completed manufacture. So it cuts both ways for the contractor. So the primary answer to your question is that look at the construction program at the outset. Often you don't get to see all of it. You're given a time scale. We need you to do this within that, between the 1st and the 15th of June. You accept it because it's 2 weeks delivery fitting period. But by the middle of May, please go to site, take a look. And if it isn't, that is when you start screaming, because someone will turn around and want to blame you. I wonder, Anthony, if that answers your question.
It does. Thank you, sir.
Fantastic. Thank you. Yeah, sure.
Can I ask you, sir?
Hello.
On a JCT contract, if at the date of the completion date in the contract, the architect feels that the work is not sufficiently completed to allow him to issue a certificate of practical completion, but the employer decides that he must take occupation of the building, can the architect still issue a failure to complete certificate?
That's a fantastic question. You actually touch upon 3-4 clauses of the contract instantly with that question. Now, there is, of course, practical completion, sectional completion, but there is the overall presumption in law that if you have taken occupation, the practical completion of this section that you've taken occupation is automatic. So you, the architect, cannot issue in good conscience a certificate of failure to complete for a project which is now being occupied. Now, you must therefore warn your employer, if they are desperate to take occupation, by implication, they're accepting that it is complete, or bar snagging. So practical completion is effective indeed. The day that the employer takes occupation legally, the contractor is entitled to 50% release of a retention for practical completion on that day. So there are two inconsistencies. If the architect thinks that it's not done, then the architect must endeavor to prevent the employer from taking occupation. If the employer is in a desperate situation that they must take occupation, then a separate form of words will have to be adopted to recognize the extent that the occupation has taken place. Does that make sense?
Yes, it does.
Yeah. Okay. So first of all, you look at the express provisions of a contract. You take 2 quick steps backwards and look at what the legal presumptions are, which are inescapable. You couldn't be telling a contractor he hasn't finished the building that you're living in. It simply wouldn't work. So if the architect issues a certificate of failure to complete, I would have thought that such a certificate is susceptible to attack and attack successfully. Because imagine the obstruction that occupation causes to the contractor in his efforts to complete. Because once you take occupation, remember that that the lawful occupant of the site during the course of the project is a contractor with the consent of the employer. But once the employer takes occupation,
it takes back ownership of the site.
Yes, in essence, you've excluded the contractor from the areas that you've taken occupation. They must only enter with your permission.
Sorry, can I ask a question on top of this question?
I thought one would be coming. Yes, go ahead.
So does that mean the architect doesn't have to issue his practical completion certificate?
No, well, that wasn't the question. Was whether the architect will still be entitled to issue a certificate of failure to complete.
Right. Yeah, no, I got that. And
Okay.
you're saying, but you've kind of said it would be
Ultra virus. Yeah, it's ultra virus. You can't.
Yeah.
You can't say that the building that you've occupied is not complete. That's one.
But therefore, the client's taken possession of this, or repossession of the site. There's no practical completion certificate from the architect, and the architect shouldn't be bound, correct me if I'm wrong, to issue one.
I think the contractor will be entitled to demand one and get one.
Yeah.
Really?
Yeah.
Yes, because the presumption.
So how does the architect protect themselves?
There you go. Now, I recently was dealing with one where, interestingly, this is a very large student accommodation where the employer has managed to sell a lot of the units off plan. And the employer was then financing the development on the basis that a substantial amount of money will be drawn upon the architect's issuing of the certificate of practical completion. Not only was the employer entitled to draw that amount down from his funders, practically all of the people, and there are about 350 purchases of these units, a lot of them international. You're going all the way from Africa to China and some in the United States. They were obliged on the issuing of the architect's certificate of practical completion to complete on the purchases, because of course what they've done, because they bought off plan, was to pay a deposit pending the issuing of certificate of practical completion, whereupon they would then be required to have an exchange contracts to complete. And therefore the employer stood to receive a substantial inflow into his bank account upon issuing of that certificate of practical completion.
How does a conflict of interest come into that kind of scenario though?
Well, let me finish answering the previous question and I'll come to the conflict of interest, because what's then happened was that the architect was under substantial pressure from the employer to issue the certificate of practical completion. And the architect allowed himself to issue one when the building only had 20% of the roof and 0% of the external windows and doors. Now, of course, the various purchases of these units, of course, gave survey notices on their various lenders, and whoosh, money all came into the developer's account. And it wouldn't surprise you to hear that within 30 days of this money flowing, the developer promptly went bust. So you're in a situation now where you have a development that is substantially but definitely not practically complete, substantially built but not practically complete, and proceedings were flying. And guess what? The architect was in substantial difficulty, not just on professional negligence claims on their PR, but of course, before the professional institution for disciplinary, which of course, you can imagine how that one went in the end. So how does conflict of interest play? Whose conflict of interest? The employers?
Well, he's a contractor and a developer.
Yes. Now, clearly, the person who holds the ring there is the architect. And the architect, and this is literally an object lesson in architects recognizing the professional exposure they face when they're being required to issue certificates. your certificates are, as architects, have substantial legal implications, and you must not issue them lightly. And your employer, of course, is paying you, potentially a good friend of yours, and will insist that you issue certain certificates. Now, consider issuing the certificate and the state of health of your practicing certificate, really, because your practicing certificate can be severely compromised. You know, of course, that when there is a successful professional negligence claim, your professional indemnity insurance premium for the next year goes through the roof.
Yeah.
Exactly. So there is a substantial issue there. There is always a conflict of interest from a developer contractor perspective. Again, contract objectives, contractual obligations, attempt to recognize it at the earliest possible opportunity and make clear to your client what is achievable and what isn't achievable.
What was the format of that? What type of contract was it? Was it a JCT or was it a design and build?
Remember what I said at the opening of my remarks, that an appropriate choice of contract is very, very, very important. So that was a JCT contract, to answer your question. But in certain circumstances, may be inappropriate as well.
I remember an occasion, I finished the building back in 2001. It was a building for Imperial College.
Okay.
And the contractor, Kier, and the client wanted to take occupation. And the contractor and I and the client were standing in the main hall. It was almost finished, but it wasn't practically complete.
Mm-hmm.
And he said, well, it's practically complete to me. I said, unfortunately, that's a matter of opinion and yours doesn't count.
You're telling your employer?
No, the contractor.
Oh, of course. So the contractor, they want every contractor will want a practical completion certificate at the earliest possible opportunity.
Yeah.
For
I refused to issue it. And it was only a matter of weeks. So, they actually got it done. But all of these issues, but once you issue it too early, you're opening yourself up to a whole level of liability.
Big time. The defects liability period begins to run.
Yeah.
Releasing of retentions kick in. A whole host of legal implications kick in, which is good.
Hi, Samuel. Do you have time for another question?
Yeah, go ahead, of course.
I work for an MEP subcontractor, and I'm in a position at the minute of negotiating JCT subcontracts with main contractors who have already got their main contracts in place, perhaps before all of the price increases and the delays to the supply chain, and they don't have fluctuation clauses in their main contract. Yes, and we're seeing 50% up to 115% price increases for steel and things like that.
Mm-hmm.
And I was wondering, have you ever seen clauses that maybe put certain caps, like as a relevant matter, like say, for example, if steel goes above X price, this is a relevant matter and you can claim for it? Have you seen anything like that?
So suffice it to say that provided the contracting parties pre-agree a provision, then it can be imported in the contract. So if I'm hearing you correctly, you are a specialist subcontractor to a principal contractor who is already locked into what is a lump sum fixed price main contract.
Yeah.
Now, what every main contractor would want to do in those circumstances will be to drag you in on similar terms upon which that they've been bound themselves. Ask yourself, is that worth that risk? It clearly, if it is worth the risk, it follows that you must substantially overprice for the time being in order to secure the contract. The likelihood is that you won't secure the contract if you overprice. So what you want to do is suggest a clause to the principal contractor that must go into your own subcontract. And that is a fluctuation clause, which they are lacking. And indeed, a sensible main contractor in these circumstances ought to return to the employer to say, look, circumstances have changed. Can we talk? And every prudent employer ought to listen to their contractor there for the reasons that I've already given in the body of my webinar. Because if the price increases are such that the main contractor can't carry on, you may well find them becoming extra claims conscious, or in the extreme, as silly and as stupid as it sounds, abandoning the contract. Now, if you're an employer and the contract is abandoned, as you well know, every single contractor that comes to see it will start by condemning everything that's been done ahead of them. And then, of course, giving you a price for trying to, as it were, repair everything that went wrong prior to doing the new work. So sometimes, including a provision helps, but in your own particular case, as a trade contractor, you are going to sensibly communicate to the trade contractor and say, look, because of the circumstances of the market, it is so uncertain that you ought to allow a fluctuation clause. You may well include that you are quoting at these rates. Anything of fluctuation of about 5–10% you will absorb. But above that, you ought to return to them with a view to having that accepted. And it will be advisable to draft a bespoke clause to put to them, depending on the value of the contract. And it is necessary for you to protect yourself, because it isn't surprising, as you well have identified, that prices are up 50–100%. You're simply going to be paying the contractor to do the work. And if you're locked in such a contract, you will rightfully expect an attack on you when you fail to deliver.
Yeah.
Okay.
Thanks.
Yeah.
Thanks.
So good luck on that. Okay. Okay. I think we're. Do we have any more questions?
There are no more questions, Samuel.
No more questions. Good. Okay, if we are lacking questions at this stage, and I think we have sensibly consumed our dedicated hour, so it's my pleasure to thank you once more for attending. I hope it was beneficial for you. And if it was beneficial for you, by all means, acknowledge it. And if you think you want to follow up with any specifics subsequently, have no hesitation in contacting my clients. Otherwise than that, and thank you very much, and wish you a fantastic evening, what's left of it.